Under which section of the Indian Evidence Act 1872 a public servant shall not compel to disclose the communication made to him in official confidence. Section 124. No revenue officer shall be compelled to say whence he got any information as to the commission of any offence against the public revenue. This provision contained in Section 125 of Evidence Act. A client says to B, an advocate, I have committed forgery and I wish to defend myself. His communication is protected from disclosure because Section 126 of the Evidence Act. In which one of the following statement is correct? Admission of the fact made by pleader in court on behalf of his client is evidence. Nothing in Section 23 of Indian Evidence Act 1872 shall be taken to exempt any barrister, pleader, attorney or vakil from giving evidence of any matter of which he may be compelled to give evidence is such provided in Indian Evidence Act under Section 126. Consider the following statement. Privilege granted to lawyer under Section 126 aim to protect the lawyer. Which one of the following fact protected from disclosure in a court of law? A client says to B, an attorney, I have committed forgery and I wish to defend myself. A wrote a letter to his lawyer X that he is going to commit theft. In the case of apprehended, he should be protected. Can X statement against A is in case of charge of the theft? Yes, it is not a charge, it is not a privileged communication except an information to the third party. The provisions of Section 126 of Indian Evidence Act deal with confidentially of professional communication shall apply to clerk and barrister, servant and pleader, interpreter and barristers. The professional communication between an advocate and his client can be disclosed before the with the consent of the client, without the consent of the client if made in the furtherance of any legal purpose, without the consent of client if the advocate comes to know that any crime or fraud has been committed since the commencement of his employment. Which one of the following statement is not true? The professional communication between an advocate and his client can be disclosed before the court without the consent of client. Communication by the client to an advocate is not permitted to disclose under Section 126 of the Indian Evidence Act 1872. Professional communication between an advocate and his client is admissible in evidence and with the consent of the client. A client says to B, an advocate, I wish to obtain the possession of property by using false deed on which I requested you to sue. This communication is not protected from disclosure. Which one of the following is mismatch? Confidentially communication with legal advisor 126. Section 129 of Indian Evidence Act 1872 states that no one shall compel to disclose a court any confidentially communication between he has taken place between legal professional advisor and his client. If question asked to a witness to any matter relevant to a matter in issue and the answer given by witness to such question will criminate him, then the witness shall be compelled to answer such question. Testimony of accomplice between accepted and acted upon need not to be corroborated at all. An accomplice is a competent witness under section 133 of Indian Evidence Act. An accomplice shall be a competent witness against the accused person, and the conviction is not illegal, merely it is proceed upon uncorroborated testimony of accomplice. Which one of the following section of Indian Evidence Act enunciated this aforesaid principle? Section 133. Which one of the following section of Indian Evidence Act related to accomplice? Section 133. Which one of the following provided under section 133 of Indian Evidence Act evidence of an accomplice? Select the right option based on the following assertion reason. The evidence of an accomplice required to accept with a great degree of caution and security he hoped for pardon or has it is so favor the prosecution. Husband and wife both are competent witness for and against each other in both civil and criminal proceedings. Which one of the following statement is correct with respect to accomplice? An accomplice shall be a competent witness against an accused person. An accomplice is a competent witness against an accused is provided in which one of the following section of Indian Evidence Act 133? An accomplice shall be a competent witness against the accused person. An accomplice is unworthy credit unless he is corroborated in material particulars. What is the provision about accomplice? His evidence is relevant under section 140 and 133 of the Act. Which of the following statement is not true? C is not true, 1 and 2 is true. An accomplice is a competent witness against the accused person. Conviction on the testimony of an accomplice is legal. Who among the following is an accomplice? Prostitute. Which section of the Indian Evidence Act deal with accomplice? Section 133. Who among the following is not an accomplice? A detective. Which one is an accomplice? Is bribe giver, prostitute, a person receiving stolen property. Mark the correct answer. Accomplice is unworthy of credit unless he is corroborated in material particular. Accomplice shall be competent witness against an accused, and conviction is not illegal merely because it proceed upon the uncorroborated testimony of an accomplice. Evidence of an accomplice is relevant under section 133. Dagdu versus state of Maharashtra is related to accomplice. Who among the following is not an accomplice? All of the above. A trap witness, a raped girl, an eyewitness to a murder. An accomplice is competent witness under section 133 of Indian Evidence Act. Which one of the following statements is incorrect about accomplice? Court may tender pardon only in those offences which is punishable up to 7 years of imprisonment. Which one is correct? Court may tender pardon to accomplice under section 306 of CRPC. It is necessary for the court to record its reason in the every case of pardon. The object of pardon is to obtain evidence from the accused. Testimony of an accomplice before it accepted and acted upon need not to be corroborated, but corroboration is required to as a rule of guidance. In trial of murder, rape, dacoity, number of witnesses required 10, 8, 6 respectively. No particular witnesses number of witnesses is required. One of the most important principle of law of evidence is that evidence is wished and not to be counted. This has to be incorporated under which section of Indian Evidence Act 1872, mainly under section 134. Under Indian Evidence Act, what is the number of witnesses which is required to prove any fact? No number of particular witness. What is the number of witness required to prove any fact in case? No number of particular witness. Section 134 of Indian Evidence Act provides a set number of witnesses in the case of requirement of proof. None. How many witnesses are necessary to prove any fact? No number of witnesses is required. Who among the following is an accomplice, a prostitute? Which one of the following is not correctly matched? Confidential communication with legal advisor, section 127 is not correctly matched. Matrimonial communication 122, official communication 124, professional communication 126. An approver's statement must be reliable and preferably corroborated. What is not true about the mode of proof of will? B is not true. What is true? One attesting witness at least to be examined. Not proof required if it is admitted by hear of an executant, where the attesting witness is not found, handwriting of attesting witness and signature of executant must be proved. Who among the following statement is correct? Which one of the following statement is correct? The protection of professional communication as to provided under Indian Evidence Act 1872 in section 126 and 129 to 129 is available only after commission of a crime of illegal acts. What is the number of witnesses which is required to prove any fact? No particular number. He is accused before a court of section and attempting to murder of a police officer whistle on his trial before B. A session judge can be examined as to what is occurred. Which one among the following is common in the provision of section 123, 126, 127 of Indian Evidence Act? They are relevant but inadmissible. A dumb person is competent witness as a provider under section 119 of Indian Evidence Act. Which one of the following section of Indian Evidence Act apply to a pleader relating to professional communication? Section 126 and 129. A witness who is unable to speak is called dumb witness. Which one of the following is not a privileged communication? Paternal communication. Evidence act by a dumb witness according to section 129 can be treated to be oral evidence. Which one of the following is correct statement according to law? An accomplice shall be competent witness against an accused person. A leading question may be asked in cross-examination of witness. The court may permit any party who call a witness to put any question to him who might be put a cross-examination by the adverse party. A magistrate can be compelled to answer question on his own conduct as a magistrate in the court by an order of a court to which he is subordinated. Who among the following is competent to adduce the evidence under Indian Evidence Act? Dumb witness, deaf witness. A statement of a solitary witness can be relied upon if the court conclude it to be correct and true. Under Indian Evidence Act 1872, which among the following does not? Come under the category of privileged communication. Communication made by witness who is unable to communicate verbally. Which one of the following statement is not true? Three is not true, 1 and 2 is true. An accomplice is a competent witness against the accused person. Conviction on the testimony of accomplice is legal. Under section 118 of Indian Evidence Act, who among the following is not a competent witness? Lunatic. One on whom does the burden of proof lie? On prosecution. Chapter 10 of Examination of Witnesses, section 135 to 136. Which section of Indian Evidence Act provide a judge will decide as to admissibility of evidence? Section 136. Admissibility of evidence is to be decided by the judge. Under which section of Indian Evidence Act admissibility of evidence shall be decided by the judge? Section 136. Under which one of the following section of the Indian Evidence Act judge determine the admissibility of the evidence? Section 136. Under which section of the Indian Evidence Act admissibility shall be decided by the judge? Section 136. Examination after the cross examination of witness by the party who called him is called re-examination. During re-examination of a witness, a new matter can be introduced only with the permission of the court. During the examination in chief and re-examination, leading question of a certain matter can be asked only with the permission of the court. The right of cross-examination on the answer to the court question is available to either to the party if the answer is adverse to either of the parties. Cross-examination of a witness must relate to the relevant fact but need not to confine to what the witness testify in the examination in chief. Cross-examination under section 137 of Indian Evidence Act means one of the following: examination of witnesses by the adverse party. Cross-examination of one's own witness is permissible only after obtaining the permission of the court. The question in the cross-examination need not to be confined to the fact testified by the witness on his examination in chief. After re-examination of witness, the adverse party has a right to further cross-examination the witness only when the new fact is introduced in the re-examination. Leading question can be asked during cross-examination. To an answer to the court question, the adverse party has right of cross-examination only with the permission of court. Under which section of Indian Evidence Act provision regarding examination in chief is provided? Section 137. What is re-examination of witnesses? Cross-examination of one own witnesses. Examination of chief means examination of witness by the party who call him. Re-examination of a witness can be for the purpose of explaining the matter referred in the Cross-examination. Right to cross-examination of a witness has adverse party. Leading question without the permission of court may be asked in cross-examination. Which of the following is not lawful in cross-examination? A question, the answer of which amount to hearsay. The term examination of chiefs has been defined in Indian Evidence Act 1872 in section 137. Examination of a witness by adverse parties shall be called his cross-examination. The right of cross-examination on the answer to the question is available to the adverse party only. Examination of witness in criminal cases through video conferencing is permissible. During re-examination of witness under Indian Evidence Act, a new matter can be raised only with the permission of the court. Re-examination of a witness shall be by the party calling the witness. Cross-examination under section 137 of Indian Evidence Act means which one of the following? Examination of a witness by the adverse party. Examination after the cross-examination of a witness by the party who has called him for re-examination. The object of cross-examination is to examine the credibility of the witness. Point out the incorrect statement. No new matter should be introduced in the re-examination without the permission of the court. What is examination in chief? Examination of witness by the party who call him. When shall the witness be re-examined? At the desire of the party calling him. Party calling a person as a witness can be cross-examined with the permission of the court. During which one of the following leading question may be asked? Cross-examination. A party may put any question to the witness called by it with the permission of the court. What are the questions which are lawful in cross-examination? To test veracity, to discover who is he, to take the credit by injury his character. Cross-examination of one's own witness is permissible only after obtaining the permission of the court. The question in the cross-examination need not to be confined to the fact testified by the witness on his examination in chief. A party who call a witness can be put any question to him which might be put in cross-examination by the purpose of the party which with the permission of the court. What is the object of cross-examination of witness? To destroy or weaken the evidentiary value of the witness of adverse party. In a criminal trial, during examination in chief and re-examination, leading question can be asked on certain matter but only with the permission of court. Which one of the following is true? There can be a further cross-examination after re-examination as per section 138. A person summoned to produce a document, when produces the document, then he does not become witnesses and cannot be cross-examination unless and until he is called as a witness. What is not true? Person called to produce a document can be cross-examination. Which one of the following is not correct? Witness summoned to produce document can be cross-examined. Which one of the following is correct? A person summoned to produce a document does not become a witness by mere fact that he produces it, and cannot be cross-examined unless and until he is called as a witness. Which statement is incorrect? Witness to character shall not be examined. Which one of the following is correct statement relating to cross-examination? Witness to character may be cross-examined. Which one of the following section of Indian Evidence Act contain provision relating to cross-examination of witnesses to character? Section 140. Any question suggesting any answer which a person putting to wishes accept it to receive is called leading question. In relation to a court question, the adverse party has right to cross-examination as a matter of right. Leading question can be asked during cross-examination. Which one of the following statement is correct? Leading question may be freely asked in cross-examination. Leading question has defined under section 141 of Indian Evidence Act. Leading question may be asked in cross-examination. When can leading question may be asked in cross-examination? Leading question can be asked in cross-examination only. Leading question can be asked during cross-examination. According to section 141 of Indian Evidence Act 1872, and question suggesting the answer which a person putting to wish or accept to receive is called a leading question. Any question suggesting the answer is called leading question. Leading question has been defined under the Indian Evidence Act 1872 under section 141. Leading question may be asked in examination in chief with the permission of the court as to the matter which they are introduced, if the opinion of the court the matter involved has been already sufficiently provided. Leading question can be asked as a matter of right during the cross-examination. Under which one of the following condition a leading question may be asked during examination in chief with the permission of the court? Where matter in question is sufficiently provided. Leading question can always asked in cross-examination. Under Indian Evidence Act 1872, leading question may generally be asked in cross-examination. Leading question may be asked in cross-examination. Leading question may be asked in cross-examination. Any question suggesting the answer which a person putting to wish or accept to be received is called leading question. When can leading question be asked? In all the above situations: cross-examination, examination in chief with the permission of the court, and re-examination with the permission of the court. Which section of Indian Evidence Act deal with leading question? Section 141. What is the leading question? Any question suggesting the answer. When can leading question be asked? In cross-examination, in examination in chief with the permission of court, in re-examination with the permission of court. A leading question can be asked during cross-examination. A leading question is that question which suggests answer. Under section 145 of Evidence Act, witness may be cross-examination as the previous statement in writing without proving the same and without showing the same to the witness. Under section 145 of Indian Evidence Act, A witness may be contradicted as to his previous statement in writing after drawing his attention to the previous writing. Under Section 145 of Indian Evidence Act, a witness may be cross-examined as the previous statement in writing without proving the same, without showing the same to the witness. Previous statement for the purpose of contradicting the witness under 145 does not include a statement made by witness as to the accused in the previous case. Under proviso of Section 146 subclause 3 of the Indian Evidence Act, in the prosecution of rape, in her cross-examination, the prosecutress cannot put question as to her general immoral character. In the prosecution of offense under Section 376 of IPC, where the question of consent is in issue, it shall not be permissible to adduce evidence or to put question in the cross-examination of the victim as the general immoral character of previous sexual experience of such victim with any person for proving such consent or quality consent by provided in which section of Indian Evidence Act? Section 146. Which one of the following provision of Indian Evidence Act 1872 has been amended by Criminal Law Amendment Act 2013? Section 146. In the prosecution of rape, the question in cross-examination of prosecutress as to general immoral character are not permissible. Under Indian Evidence Act 1872, question relating to matter not relevant to suit or proceeding may be asked under Section 148. In which one of the following circumstances there are no reasonable ground for putting the question to witness? A witness or whom nothing whatever is known is asked at a random whether he is a dacoit. In which one of the following instance there is no ground for asking a witness the question whether he is a dacoit? A witness of whom nothing whatsoever is known is asked randomly whether he is a dacoit. A barrister is instructed by the attorney or vakil that is important witness a dacoit. This is a reasonable ground for asking a witness whether he is a dacoit. The illustration is based on which one of the following section of Indian Evidence Act? Section 149. An indecent and scandalous question may be forbidden by the court under Section 151. Under Indian Evidence Act 1872, the court may pretend such question which is regarded indecent and scandalous they related to the fact in issue. The provision relating to the hostile witness is provided in Section 145 of Indian Evidence Act. Which section of Indian Evidence Act was amended by Criminal Law Amendment Act 2005, Section 154. A is indicated for the murder of B. C says that B, when dying, declared that A had given B the wound of which B died. Evidence is offered to show that the previous occasion C said that wound was not given by A. Which one of the following is the correct evidence? Admissible under Section 154 of Indian Evidence Act. Which section of Indian Evidence Act deal with the hostile witness? Section 154. When can prosecution be allowed to ask leading question to its own witnesses? When the witnesses is declared hostile. Section 154 of Indian Evidence Act deal with which one of the following? Hostile witness. The Criminal Law Amendment Act 2005 amended Section 154. Under Indian Evidence Act 1872, the statement of hostile witnesses can be acted upon. Under Indian Evidence Act 1872, evidence of a hostile witness, it can be relied on the prosecution as well as defendant. A party can ask a question to his own witness under which section of Indian Evidence Act 154. During the examination in chief of the case of section 352 of IPC, victim denies the prosecution case. Under what provision of Indian Evidence Act victim may be asked leading question by the public prosecutor? 154. Testimony of hostile witness is to be considered with caution and be corroborated. Hostile means an unfavorable witness. What opinion is available to the commissioner when the party seeks permission to the cross-examination of his own witness? He may ask party to first obtain the permission of court under section 154 of Evidence Act. By which one of the following way under Indian Evidence Act 1872, credit of a witness may be impeached by adverse party? By the evidence of a person who testified that they, from their knowledge of witness, believe him to be unworthy of credit, by proof that the witness has accepted the offer of the bribe, the proof of the former statement inconsistent with any part of his evidence which is liable to be contradicted. Which one of the following provision of Indian Evidence Act has been omitted by Amendment Act 2002, Section 155, Subclause 4? A statement of an injured person is recovered as a dying declaration. However, he survived. His statement is admissible under which section of Evidence Act? 157. A statement of an injured person is recorded as a dying declaration. However, if he survives, his statement is admissible in Indian Evidence Act under section 157. The former statement of a witness may prove to be corroborated later testimony as to the same fact as provided under section dash of the Indian Evidence Act, section 157. Which one of the following statement is correct? A dying declaration made under section 32 of Indian Evidence Act 1872 is subject to the control of section 157 of Indian Evidence Act 1872. Under which section the fact proved under section 32 and 33 can be contradicted as per the Evidence Act under section 157. Which one of the following statement is correct? A dying declaration made under section 32 of Indian Evidence Act is subject to the control of section 157 of Indian Evidence Act. 158. Under which provision of Indian Evidence Act witness can be refreshed his memory? 159. Under which section of Indian Evidence Act witness has given right to refresh his memory? 159. Under which one of the following section of Indian Evidence Act witness under examination get right to refresh his memory? 159. A witness may, while under examination, of refreshing his memory by referring to the writing made by himself at a time of transaction as soon as afterward. This provision is provided under section 159. Section 159 of Indian Evidence Act is for witness can be rephrased his memory. In which one of the following section of Indian Evidence Act 1872 provision to rephrase memory has been given? Section 159. A witness can not rephrase his memory by referring to another witness taking his assistance. Which one of the following statement is not correct? Rephrasing a memory by witness under section 159 of Evidence Act means referring to another witness for taking his assistance. By following is not example of best evidence rule. Section 164. Judges has to power to put question or order production of document. What is not true? Parties shall be entitled to cross-examine the witness upon the answer given in reply of such question as are right. Court question under section 165 of Indian Evidence Act can put to any witnesses, any party. Under which section of Indian Evidence Act a judge is empowered to ask a question relevant or irrelevant to the witness or a party to the suit? Section 165. Which section of Indian Evidence Act conferred power on the trial court to put any question to any witnesses? Section 165. Under Indian Evidence Act 1872, power to judge and put a question in order to production of document or things has been provided under Section 165. To answer to the question, the adverse party has right to cross-examination any permission to the court. If any advocate asks a question without reasonable ground, the prosecution court adopt report to State Bar Council. In the relation to affair, which one of the following statement is not correct? It cannot be used as a previous statement for any purpose. Documents which are meant for cross-examination of witness of other party or meant for refreshing the memory of the witnesses may produce at any time when they are required. In Evidence Act, leading question may be asked during cross-examination. The examination of witness by the party who called him is examination in chief. Witness who laid down the party who called him is hostile witness. Examination of witness by the adverse party is cross-examination. Question suggesting the answer which the person putting it wishes to accept the device. Leading question. Which is the most appropriate definition is relation to hostile witness. A hostile witness is one called by the party to prove a particular fact who failed to prove such fact or prove any opposite fact. In a joint trial where several accused persons are being tried, one accused examination himself as a witness. Now, only that co-accused has right to cross-examination the accused, examining himself as a witness against whom such an accused has deposited something. The general principle of law of evidence is that the judge who will decide the admissibility of evidence, when the judge is in doubt as to admissibility of particular piece of evidence, he will follow his discretion. Which of the following question cannot be asked in the cross-examination? Cannot be asked. 1 and 2. Question which is scandalous but having the bearing on the question before the law In a proceeding of rape, question as to the general immoral character of victim. A witness in the criminal case was contradicted under Section 145 of Indian Evidence Act with the statement of another witness made in course of the investigation. The procedure is illegal. For deciding whether or not a witness shall be compelled to answer the question, the court shall have regard the consideration which include as to whether such questions are proper, if true, imputed, conveyed thereby would seriously affect the opinion of the court and credibility of witness on the subject matter of his deposition. The judge's power to put question or order producing or a document does not include authorization to compel a witness to answer any question which such witness entitled to refuse to answer if question were asked by adverse party. In which one of the following judgment derived by the Supreme Court in 2015, it would be held that it will be imperative if the examination in chief is over, the cross-examination should be completed in the same day. Vinod Kumar vs. State of Punjab. Which is the correct order of the examination of witnesses? Examination in chief, cross-examination, re-examination. Which one of the following is true about FIR? It is not a substantive piece of evidence. Which one of the following is not correct? B is not correct. Leading question may be asked in cross-examination. A person summoned to produce document does not become a witness. A party with the permission of the court examine his own witness. These are correct. A witness was asked whether he was dismissed from the post of dishonestly. He denies it. The evidence is offered to show that he was dismissed for dishonestly. The evidence is inadmissible. When the party refused to produce a document which he has noticed to produce, he cannot be used the document as evidence without the consent of opposite party or order of the court. Right to cross-examination of an answer to the question is available to either of the party if the answer is adverse to either of the parties. A is indicating for murder of B. C says that B, when dying, declared that A has given B the wound of which B died. Evidence is to offer to show that on the previous occasion C said that the wound was not given by A. Which one of the following evidence is correct? Admissible under Section 155 of Indian Evidence Act. Which question shall not be asked in examining a witness? Which is intended to insult, which is intended to annoy, which appear to be needless, offensive. Indecent and scandalous question, Section 151. Impeaching the credit of witnesses, Section 155. Question intended to insult and annoy, Section 152. Question by party to his own witness, 154. Mark the correct statement. The questions which are put only to test the credibility of person will not be allowed as interrogatories, although they may be asked in cross-examination. Interrogatories can be administered only to a party to the suit, not witness, whereas cross-examination can be of any person, parties, witness alike. A party filing affidavit in reply of interrogatories can neither cross-examination nor adduce evidence to contradict it as a conclusive proof. Which one of the following is not correct? Refreshing the memory by witness under section 159 means is not correct. Referring to any writing made by another person read by the witness, referring to any copy of document witness of the court permission, referring to another witness taking his assistance. Chapter 11 Improper Admission and Rejection of Evidence, section 167. Which one of the following chapter of Indian Evidence Act deal with witnesses? Chapter 9. Which section of the Indian Evidence Act makes provision there shall be no new trial on the ground of improper admission and rejection of evidence? 167. Miscellaneous. Which section of Indian Evidence Act provides that improper admission and rejection of evidence shall not be ground of itself for new trial? 167. And A scriptural agree to shall be all modes. A has both models and tool. Whether the admission can be adduced to show the intention? Yes. Which one of the following combinations are not correctly matched? 2 and 4 are not correctly matched. Correctly matched are voluntary and directly acknowledgement of guilt admission. Extrajudicial confession must be corroborated. Section 60 Oral evidence. Section 144 141 Leading question. Section 154 Hostile witness. Section 159 Hostile witness or 154 Refreshing memory. 154 Hostile witness. 159 Refreshing memory. Which of the following statement is correct relation to evidence? Sir James Stephens prepare and draft the act. Previously has been made. Opinion of handwriting expert. 53. State the relevancy of fact of person who is dead and cannot be found. 32. Previous good character in a criminal case. 47. Oral admission as to content of document. 22. The evidence unearthed by the sniffer dog fall under scientific evidence. Law of evidence is lex fori. A statement is a genuine, admission is specific, and confession is subspecies. A statement is a genus, admission is a species, and confession is subspecies. Mark the incorrect statement. A is incorrect. That the evidence must be relevant in order to admissible. That the fact which are relevant may not be admissible. The relevancy is a genus and admissibility is a species. Which one of the following statement is correct? The Evidence Act applied to the proceeding whose object is to determine a dual relation between one person and another. Indian Evidence Act applies to none of the above. Administrative tribunal proceeding, arbitration proceeding, contempt proceeding. Blood strain and blood group are State of Gujarat versus Chota Lal Patni, automatic camera, B versus Attorney General, tape recorded statement, Rake versus Dodson. Handwriting, His Philly versus State of Maharashtra. Which one the following parade is not correctly matched? D is not correctly matched. That a man heard and said something is a fact. Map or plane is a document. Copies made from compared with the original is evidence. The Indian Evidence Act 1872 is not exhaustive. Many rules relating to the law of evidence is contained in Code of Civil Procedure 1908. Indian Evidence Act 1872 applies to none of the above. Proceeding under Administrative Tribunal, proceeding under Commission of Inquiry Act 1952, proceeding before Industrial Tribunal. Indian Evidence Act deal with presumptio juris, presumptio hymnis. A is accused of child's murder. The following facts are constructed in the case. An hour before the murder, A went to the place of murder with the child. A is alone returned. Collar of A's shirt found in the blood stain. All are circumstantial evidence. Mark the incorrect statement. A is incorrect. All admissible evidence is usually relevant, but all relevant evidence is not admissible. Relevancy is a genus, which admissibility is a species. Relevancy and admissibility is neither synonymous nor is one of the include the other. Indian Evidence Act is drafted by James F. Stephens. Evidentiary value is related to confession is that it is became other evidence from only the evidence. Under the Evidence Act, fact means both factum provendum and factum provens. Draft Bill of Indian Evidence Act were prepared by Sir James Stephens. Indian Evidence Act does not apply to proceeding before arbitrator, departmental proceeding, disciplinary proceeding in educational institution. Many rules of law of evidence are contained in CPC Limitation Banker Book Evidence Act. Appreciation of evidence is question of law. Who among the following is not a competent witness? Accused person in proceeding in which he is an accused. Circumstantial evidence is indirect evidence. Which one of the following is true as to the standard of proof in civil and criminal proceeding? In civil proceeding, it is upon the balance of probability and it is beyond reasonable doubt in criminal proceeding. Burden of proof, section 101. On whom burden of proof lie, 102. Burden of proof as to particular fact, 103. Burden of proving fact especially within the knowledge, 106. Indian Evidence Act does not apply to arbitration proceeding. The law of evidence consists of only one of the following legal rules of evidence. Law of evidence is adjective law. Relevancy is the question of law can be raised at any time. Circumstantial evidence must be satisfy the following test. The circumstances from which an inference of the guilt is to be drawn must be contingently and firmly established. How many sections and chapters are there in Indian Evidence Act? 167 section and 11th chapter. The Bill of Evidence was prepared by James Stephens. A fact is a personal knowledge of the judge cannot be taken in evidence which case has been held at Har Prasad versus Shiv Dayal 1876. Under Indian Evidence Act, the evidence given by dog squad is admissible. Indian Evidence Act consists of 11th chapter 167 section. Indian Evidence Act drafted by James F. Stephens. Relevancy and admissibility under Indian Evidence Act are neither synonymous nor coextensive. Presumption of the fact under Indian Evidence Act 1872 are based on logic, human experience, and natural event and law of nature. Which one of the following is correctly matched according to Indian Evidence Act 1872? None of the above. Indian Evidence Act 1872 does not expressly mention circumstantial evidence. Under Indian Evidence Act 1872, motive became more relevant in case based on circumstantial evidence. Draft of Indian Evidence Act 1872 was prepared by James F. Stephens. A is accused of waging war against the government of India by taking part in the armed insurrection. The property is destroyed at A. X. Troops attacked at Y. The goals are broken open at Z. A was present at X, Y, but not Z. Occurrence of X, Y, Z are relevant. Law of evidence is Lex Fori. Law of evidence was drafted by Sir James Stephens. 159 refreshing memory, 154 hostile witness, 60 oral evidence, 141 leading question. Indian Evidence Act does not apply to the proceeding before arbitrator. Preposition under Indian Evidence Act are presumption of fact are always rebutable. Presumption of law can be either rebutable or irrefutable. Circumstantial evidence is considered weaker evidence as compared to direct evidence because it has two errors of fallibility of the fact from which inference is drawn and is provided. Second, of the inference is drawn from the fact is proven. Preposition of law of evidence is that 1 and 4 is not true, 2 and 3 is true. Act of central government may be proved by record of department, certificate head of the department. Act of the statement may be proved by the document purporting to be printed by the order of such government. The material fact on which party relies is called factum provendum. Which one of the following statement in respect of admissibility and relevancy is correct? Admissible fact is always a relevant fact. Relevancy and admissibility under the Indian Evidence Act 1872 is neither synonymous nor coextensive. Which one of the following cases related to judicial notice of Indian Evidence Act? Hari Shankar Jain versus Sonia Gandhi. A sale to be a deed. My estate Raipur contain 200 bigha. A has estate Raipur containing 200 bigha. Whether the evidence may be given of the fact that estate meant to be sold on one situated different from the place of the different size? No. X is tried for committing a murder of Y by administering poison. The fact that before Y death X possesses a similar poison relevant because the fact reveals the conduct of Y before incident. Which court gave the final judgment in Paklan and Swami versus King Emperor Privy Council? How many sections and chapters in Indian Evidence Act? 167 section 11 chapter. Evidence obtained by undesirable means is admissible and otherwise irrelevant. The court said so in Puspa Devi versus M. Jetia and M. Wadhwa. In the matter of kidnapping and rape, the evidence given by prosecutor being illiterate and rustic women, some contradiction and omission of the natural as the recollection memory obtained in the narration of event. It has been held in Supreme Court in 2011 by State of UP versus Chotelal. When was a special provision as to evidence relating to electronic record added in the Evidence Act? Year 2000. Which one of the following is called the best evidence? Document which is no predecessors. An evidence sought through unfair means is admissible if relevant. Hostile witness means an unfavorable witness. Indian Evidence Act deal with relevancy of evidence, admissibility of evidence. Grave and sudden provocation is a question of fact. Evidence Act applies to judicial proceeding of the court. Presumption under law of evidence are presumption of fact, presumption of law. Indian Evidence Act applies to none of the above. Proceeding before tribunal, affidavit presented to any court officer, proceeding before arbitrator. Which one of the following is relevant may be received in evidence? Tape recording, dog tracker, narco analysis test. Decision of the probate court is judgment in the realm. Mark the incorrect statement. Is incorrect. All admissible evidence are usually relevant, but all relevant evidence are not admissible. Relevancy is a genus of which admissibility is a species. Relevancy and admissibility neither synonymous nor one is include the another. Evidence Act, in which decision 5 golden principle punch seal about the circumstantial evidence has been laid down. Sarad Badhai Chand Sarda versus State of Maharashtra 1984. Evidence Act. Judgment of a civil court is binding on the criminal court under all circumstances. The statement is false. A borrow rupees 200 from B and execute a pro note in which the interest rate is given by 1%. The pro note is failing provided in the court. A want to lead evidence to effect that the interest of settlement between the party was 0.5%. This evidence cannot be allowed. Mark the incorrect statement. In criminal case, the fact that person accused is a good character is irrelevant. Which one of the following evidence is generally not admissible in court of law? Hearsay evidence.